back on the record to take up the matter of State of Idaho v. Stacey Wondra. This is in case CR 3825-1295. I did have a meeting with counsel in my office or about the time we were scheduled to take up this case. After lunch, I was informed by the state that they intended to file an amended complaint, which I received a couple of minutes ago. Has the defense seen the amended complaint?
We have, Your Honor.
Mr. Duke, if I could have you stand and raise your right hand to be sworn.
Yep.
Do you solemnly swear and or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do. Mr. Duke, do you swear and affirm that you believe there's a reasonable basis in fact and in the law to charge Mr. Wondra with these three charges in Part 2 in this amended complaint?
I do, Your Honor.
All right. Thank you. Any objection from the defense to the filing of the amended complaint today?
Judge, we reviewed the amended complaint with our client and discussed with him the removal of premeditation, and this is now essentially felony murder. Explained that to him. And also the language in Count 3, adding additional words. We have reviewed that with him, and we have no objection, and we would waive a formal reading.
Okay. When you say you waive a formal reading, of course, it's my common practice to tell someone in very common terms what that means, but I presume you've done that. I'm happy to do it again. Sometimes we replow the same ground just to be sure it's covered well, but I have no concerns for myself on that with regard to that. I'd also typically explain to a person when I read it or when I tell them about the charges in a complaint, amended or otherwise, what their rights are. Would you like me to remind your client of those things, or are you satisfied that he knows?
Judge, I don't believe that's necessary. Of course, I'll leave it in the court's discretion.
Yeah, no, I don't inherently think it's necessary. I mean, this is a carefully considered case. I said I would ask you, Mr. Vaughan, I'm happy to read this complaint to you again if you want that. I'm also happy to go over your rights again if you want that.
I waive my rights, Your Honor.
What's that now?
I waive my rights.
Okay,
correction.
Well, you understand what your rights are is really what I'm asking.
Yeah.
Okay.
Yeah.
You're satisfied that you've had enough time to speak with your counsel about that? Okay. All right, then, good enough. All right, so we've reached the time that the court's going to accept the amended complaint. It's my understanding from the conversation we had in my office that the state does not intend to call any more evidence, any more witnesses in this case. Is that right?
That's correct, Your Honor. The state does.
All right. And we discussed this in my office. It was my understanding there that the defense did not intend to make a presentation at the preliminary hearing.
That is correct.
Okay, or an evidentiary presentation. All right, then. So as far as the court's concerned, then the evidence is closed. And we've arrived at the place where we would receive, I would receive closing arguments about what that evidence means from the parties. Is the state ready to do that?
We are, Your Honor.
And is the defense ready to do that?
We are, Your Honor.
All right. Mr. Duke, what presentation would you like to make, sir?
Your Honor, in this case, so the standard for prelim is that there must be substantial evidence on all elements of the crime, and if the court believes a public offense has occurred, and that there is sufficient or probable evidence, or enough for probable or sufficient evidence to show that the defendant has committed it, then he must be bound over. In the state of Idaho, aiders and abettors are principals in any action, and the place I would start off is that ordinarily credibility is not really the main thrust or concern of a preliminary hearing. However, the evidence must be plausible, and as the court's aware in this case, there is a bridge that has to, or a gap that has to be bridged, in the form that the confession that the state primarily relies on for its case, in that confession, Stacey Wondra indicated that the body of Michael Vaughan would be found in his backyard, and it wasn't. But the state, we still view his confession as credible, and that it does describe the actual events that occurred. But in order to bridge this problem of the body not being where he said it would be, there's a few things we would ask the court to look at. One, the body was buried, according to Stacey, on July 28th of July 28th of 2021, and it was not, the backyard was not searched until November of 2022. When he was asked in November what detectives could look at to corroborate his story, as far as to verify the validity of it, he indicated the trike. The trike, so the trike comes into play because he says it was on some boxes in the garage. I hadn't seen it there before. At one point he says that the story of the trike came from law enforcement, not his memory. He then changes that story and says, I remember the trike being there. It was there, and then it was gone a couple days later. His neighbor, Carson Starkey, identifies the exact trike, identifies a trike that's sitting behind the gate of the Wondra's property. Behind that gate is exactly where a live scent tracking dog showed interest when it was given the scent of Michael Vaughan in August, just after Michael had gone missing. That same tracking dog then showed interest down the bluffs in the brush there. One of the neighbors, Mr. Smith, he found the same trike identified through the exhibits, the exact same trike that Carson identified. He had found it, tried to use it for a project, and then when he realized it wasn't useful, he returned it behind the bluff sign. But the reality is that a piece of evidence that initially Stacey Wondra said he didn't know anything about, he then said it would corroborate his story. A live scent track dog followed that evidence when it was given the scent of Michael Vaughan. And so there's one component that shows some veracity to his statement that Michael was indeed put in the backyard. The other piece of evidence, or the next piece of evidence, are the cadaver dogs. Cadaver dogs are trained to alert to the scent of decomposing human remains. We had on testimony before the court at least 2 certified dogs that alerted to the presence of human remains in the backyard of the Wondra's home. And so, while not dispositive, it does show that at some point the scent of decomposing human remains was present in the Wondra's backyard. And then finally, Stacey, he identifies that at one point Michael was given a green stuffed animal that they had used as a chew toy for their dogs in order to try to calm him down. Evidence that came in through Anita Kelleher was that Kay Ramsey, the owner of that property, or the mother of Sarah Wondra, said that the dog dug up a green ear of a chew toy, but that it got thrown away before they could collect the evidence. But all of these things go to show that Stacey's statements about the trike being in play, also this green chew toy, are corroborated by the evidence that law enforcement collected and through their investigative techniques. And there's also the reality that bodies can be moved. Every time law enforcement finds one, they move it to examine it. So this is something that this is a thing that can occur. And so the first kind of main concern there, whether or not the fact that Michael was in the ground, we would ask the court to find that the confession is still plausible and that it still meets the criteria and the evidentiary standards, because it's the theory of the state that the body was moved after it was buried, according to Stacey's own comments. Next, looking at the actual confession that Stacey gave, what the court heard through the last 2.5 days is what it sounds like when a man believes that somebody is, so there are 4 people in that household that are present when Michael Vaughan is kidnapped and abducted and then taken to CUNA. What the court heard was Mr. Wondra's attempt to gain the benefit of a deal by cooperating with law enforcement whilst trying to write himself out of the story. He's very thoughtful at times, and as he goes through, his story does change, but the story changes when he's given details that law enforcement have identified, point to untruths that he is telling in his confession. And so as he tries to write himself out of the story, and one of the most clear ones here, as he says, they went to Ontario. The other people in the house did go to Ontario, but they came back before Michael was missing. And so and this is consistent with many of the details in his confession, that he tries to paint himself as a mere observer or spectator in the events that occurred in that home. But going through what it means to actually aid and abet, or what it means to be a principal in any case. Mere proximity is not enough. There must be the same culpable intent as the primary actors, as well as one of the descriptions uses community of purpose in the unlawful undertaking. Mere presence, acquiescence, or silent consent is insufficient. And so here, what we have is, well, looking at some of the case law here, because it's actually it's a unique legal obstacle for us to get over, or when Stacey denies that he was actually wanting the things to happen that happened in that home and relating to Michael, it presents an interesting legal challenge. It's actually pretty clever by Mr. Wondra, frankly. But the case law, so there's two cases in particular that I draw the court's attention to. One is State v. Colpitts, and in that, two individuals, Madsen and Colpitts, go to a third individual, Mr. Fignani's house, and Mr. Colpitts kills Mr. Fignani. The question becomes, was Miss Madsen a co-conspirator, or did she aid and abet in that by accompanying him to the property and to his apartment where the murder took place? And one of the questions the courts asked is, did she know that that was the intent of the individual who committed the murder? And was she aware that that was going to happen? And they said it was properly an issue for a jury because she testified that she didn't know he had a gun and didn't know that's what he wanted to do. And the reason I point out those facts is because what the court seems to be interested in that case is whether or not there's foreknowledge that a criminal enterprise was going to take place. Whether or not she was aware that he intended or was engaging in criminality. Similarly, in, and I'm not good at the last name here, State v. Sensenig, there's an individual who meets up with a man and his stepson, and they start their enterprise together around 5 in the afternoon, are not doing anything criminal. Around midnight, the stepson and this third party drop the father off. He engages in some burglaries, and then they come pick him up about 15 to 20 minutes later. The court identified two components here that they examined, and they determined that it was an issue for the jury. But they looked at a statement he had made, or a statement that the stepson had made while the father was not in the car and while he was engaged in his burglary. He said that his father was the stealingest man in the country. And so the courts acknowledged that that might give some indicator. And then the question was, did this third party who was with them, were they aware when they went to pick him up that he was engaged in the act of burglary when they went to pick him up? And again, in that case, what the court seemed to be looking at is, did the aider and abetter know that they were participating in some criminal act? So moving to the facts of our case, and with that in mind, and one treatise puts it well. They say, and this is just persuasive. It's a treatise on the subject, but they said that with foreknowledge comes the opportunity to abandon the criminal enterprise, or to not engage at all. Meaning that you have a choice when you know beforehand what's going to happen. In this case, kidnapping is an ongoing crime, and it is not completed until the return of the victim or until the victim is dead, and so it's no longer a kidnapping at that point. In this case, Mr. Wondra's statements are very clear. Michael Vaughan was alive when he was brought into the home, and where Mr. Wondra first identifies him, or first sees him. He's told, we've just taken this kid. He uses the word abduct, but I think she said took, but they mean the same thing. So he accepts that what has just occurred is an abduction or a kidnapping. And then he observes while the child is duct taped, placed into a duffel bag, and stored in the living room as he claims he's arguing, or he's saying, he used the word, this is fucked up, what are we doing? And so his testimony is that he objects at this point, but he very much knows that a kidnapping has just occurred, that Sarah Wondra is one of the people who is committing that Adrian Lucini is one of the people, and that Brandon Shirtliff, that those three individuals have just kidnapped a child and have placed him in a duffel bag. Stacey Wondra knows when he gets in the truck that Michael Vaughan is in that duffel bag in the back of the truck. When he leaves the house with those two individuals, Sarah Wondra and Brandon Shirtliff, he knows that they're engaged in the act of kidnapping. And he knows that it's still ongoing because he describes hearing Michael scream when they stop on 8th. And so he knows Michael's still alive and he's still going with them. One of the statements that he made is that they were trying to establish an alibi. He comments on the use of the word alibi because he says, well, in this case it's true, so it's not an alibi. That's not the actual legal definition of an alibi, but the meaning of the words he uses shows that he understands what it is they're trying to do, which is create a story that hides the fact that they're involved in Michael's disappearance. And he explicitly states that the alibi was to convince people they didn't know what happened to Michael, but that wasn't true. They did know what happened to Michael. That's how he phrases it. And so they established that alibi before they even leave. And the testimony that came in was that Brandon Shirtliff said the reason they went to CUNA was for an alibi. And we know that that's accurate because the first statement of Stacey's that Detective Kelleher reviewed was a statement that said they left at around 5 and that they weren't in the area when Michael went missing. Well, later that was determined to not be true, but that just goes to show that when he went with them to CUNA, he was helping them establish an alibi, and the alibi was to tow a car back. He brought the chain, the tow strap. And during the course of that enterprise, when they're bringing the car back, and I believe the tow strap breaks, he's the one who fixes it so they can complete that maneuver. And the important thing here is that he said the purpose of that was so people wouldn't know they were involved with Michael. One of the elements of kidnapping is to secretly convey a child to another place. And so he is maintaining the secret nature of the kidnapping when they establish the alibi so that it covers the actual actions that they're taking. When they stop on 8th, Stacey says he filled up the power steering fluid. Again, he is assisting and facilitating the transportation of Michael Vaughan because he's making sure that the vehicle is operating normally. And the reason that's important is because in order to take Michael away, to get him to a place where people aren't looking for him, they've got to drive, and they need a vehicle that's functioning properly. And so he makes sure that their vehicle is functioning properly in order to get Michael out of the area. He also comments that he hears him screaming and it's muffled, but he makes another statement during his confession. He says that he was just the DJ. But if you're worried about the sound that a child makes when they're duct taped in a bag, the only way to hide that, apart from remedying the situation of a child being in the bag, is to cover that sound with a louder sound. He said he was playing music. That is actually evidence that he was trying to further conceal the fact that Michael was with them in the truck. When they're stopped at 8th, in his testimony, he said that there was a discussion, and they said, they got to get out of here, no more stops. And so again, there's conversations about what to do about the fact that they've got Michael Vaughan in their vehicle. And another component of someone who's aiding and abetting is if they counsel with the other principals. And several times throughout his testimony, he says Sarah would ask what to do. Now, he always responded with, got to call the cops. But then he goes with them to CUNA. And so even though he says, oh, do this thing, that's the right thing to do at this point in time, his actions do not match the words he's using. He still goes with them. And so the court is allowed to infer his criminal mindset and is allowed to look at his actions even if they're not consistent with the words that he uses. And his actions are consistent with being in a I apologize. His actions are consistent with being in the same joint enterprise as the people who are committing the other primaries committing the actual kidnapping. Next, so in order to be an aider and abetter, the fact inquiry is what happens before and during the commission of the crime. But in this case, we do have some details that happen after the commission of the crime that go to show what his intent was during the commission. And so he calls Brandon and he says, we're in trouble, we need to get our story straight. And they maintain their alibi that they're just transporting or towing the Mercedes. Even though that conversation happens afterwards, we know that that's the story they had given consistently and that is what they actually did in order to create the alibi. And so the statement he makes later shows that he was indeed trying to help create an alibi when he went with Sarah Wondra and Brandon Shurtleff to CUNA to take Michael over there. And then finally on the issue of his joining in a community of purpose with Sarah and Brandon, his mindset is part of the element of whether or not he's an aider and abetter. And again, while not dispositive, the phone call he makes with his mother is very revealing. He shows a great deal of remorse, and what that indicates is that his mindset at the time he was with Sarah Wondra and Brandon Shurtleff is that he feels like he was engaged in a common scheme with them, that and so the words the courts use is community of purpose. His level of remorse is commiserate with being in a community of purpose with people who are conducting a kidnapping. Now, we know that Michael dies as a result of this kidnapping because Stacey tells us that. He also tells his mom that. He says he was accidentally suffocated. There was too much clothes on top of him. He explicitly describes watching as they put the clothes on top of Michael in the duffel bag. He observed that thing, and he watched Michael get transported and assisted in transporting Michael while he was in that condition. And so on the final thing I would say on the issue of whether or not he sufficiently joined in the illegal enterprise, is that the language that the courts use, they say mere proximity, they talk about bystanders. In this case, this isn't a person he's recently met. These aren't people who he's accidentally fallen in with. This is his wife and his friend, whom he is asked to try to assist him in siring a child with his wife. These are people he knows well. And so when he describes them as asking him things like, what should we do with him? And he says, call the cops. We got to do something about this. The reality is that he is consulting with them. And even if nobody takes that advice, he is still consulting with them. And that makes sense because these are people he lives with. These are people he lives his life with. These are people he is engaged in business with. And so all of that is to say that Stacey Wondra is engaged in the same criminal enterprise, the same community of purpose as Sarah and Brandon, and that is abundantly clear by the fact that he goes with them and assists them. Finally, speaking just on the facts, we have a pretty good idea of what happens to Michael up until he's moved from the Wondras' yard. Stacey describes that he's brought into the house by Sarah. He says she's gripping him tightly, and that detail matters because if a child is trying to get away or doesn't want to be held, you would have to grip him tightly. He talks about hearing the duct tape and then seeing Michael Vaughan with duct tape on his wrists and his ankles and over his mouth. When asked if he was resisting, he said, well, yeah, he was squirming. So he describes what it would be like for a child to struggle, but there are at least two grown adults putting him in this bag. He describes how he's too big for the bag, and so they had to bend his knees, and he describes it with a tote and a boot and demonstrates it to law enforcement. He describes how Michael is taken to the truck. Now, the fact that he's put in the bed of the truck, well, it makes sense when they stop on 8th Street that they don't know what to do with him, and that's where he was originally found. That's what Stacey's testimony is that he was found on 9th, but they stop right outside that neighborhood, and they check to see if Michael's alive. If their intent was to try to abandon their criminal enterprise and drop Michael off, it would make sense to have him in the back of the truck where they could just drop him off and leave. But when Brandon goes to check on him, right after that discussion, or right after that happens, they have a discussion and they say, we got to get out of here, we got to go. So an argument that whether or not it's credible to put Michael in the back of the truck, I would argue that it makes sense. Granted, credibility is not an issue here. Once they convey Michael, they go to Cuna and they put him on the side of the house and they leave him there. Stacey's adamant that he's still alive at this point, but then they get into their vehicles and they leave. They tow the Mercedes. Brandon's the one driving that. They tow the Mercedes, tow strap brakes. They get back into Fruitland, and then they just start trying to blend in. The court heard evidence that they put the picture on the fridge to try to blend in with everyone else. So they had a picture of Michael in the house, and he described that as an effort to blend in. After Michael goes missing, a series of actions are taken in that household. They get rid of 2 of the 3 cars that they're driving, both of which are implicated in having been used or involved in the kidnapping of Michael. They get rid of their phones. The testimony, I believe, that was elicited from Detective Kelleher is that Stacey destroyed one of the SIM cards and he said, I don't want them following me. At the time that this occurs, they've had interviews with law enforcement. They've made statements to the effect of, we're in trouble, we need to get our alibi straight. And so he knows that he's being looked at by law enforcement when he makes the decision to break that SIM card. They get rid of their furniture. and their text messages of that day are deleted. At the end of the day, what the court has before it is a man who felt pressured because he thought he was giving a competing confession to his wife. The statement was elicited that during a phone call, she said, "I won't testify against you," and he said, "I won't testify against you." Clearly there's concern from both of them that they would testify against one another. He wanted the benefit of a deal, but he didn't want to implicate himself. He even told the detectives when they began questioning him, and he wasn't talking about Michael very much, and they said, "You're not really giving us much," or I'm paraphrasing here. And he said, "Well, it's like the Miranda thing. I'm going to get hemmed up." So he is letting them know, because the Miranda warning is that anything you say will be used against you. He's letting them know that if he tells them the story, it's not good for him legally. He understands that. And based on the story that he gives, he tries to walk that line, and he's pretty clever about it, frankly. He writes himself out of every bit of every event, every piece of evidence. He says, "No, I didn't destroy things. That was them." Or at least he tries to, but he makes a few errors along the way. He does make the error when he says, trying to say that he wasn't there when Michael was abducted. He says, "I remember," when talking about 8th Street, and then backs up and says, "I mean, Sarah told me." Over the course of that interview, when he was confronted with the fact that his story was not possible, what he ended up with was something closer to the truth. As he told more of the story that incriminated him more details became corroborated, not less. And so what we're asking this court to do today is bind over Mr. Wondra for his participation in kidnapping Michael Vaughan, a 5-year-old child at the time, and also bind him over on the felony murder rule on first-degree murder because Michael Vaughan died during the commission of that felony, or as a result of that felony, and also to bind him over on the destruction of evidence as the number of attempts to get rid of normal objects in their lives is staggering. To get rid of your cars, your phones, your furniture. They took every effort imaginable to try to hide from this crime, and they were very good at it, frankly, but not perfect. And we're asking the court to bind them over on the evidence that it's heard during the course of this. Thank you.
Thank you. Mr. Geddes, would you like to make a final or make a closing?
Thank you, Judge. Some of what the state talks about is accurate. And Mr. Duke talks about how we have a unique obstacle to get over in this case. It's true. There is a gap between the evidence and the charges, and they have to overcome that, and they haven't done it. He talks about, at some length, there's this gap between when we think the body was buried November 28th to when we dug up the yard in November. So we just surmise that he must have been moved. Okay, that's called guessing. Body was never found. Talks about the tricycle and what happened with the tricycle. Guessing. The cadaver dogs. They alert. Okay, what does that tell us? That there was a body, perhaps, in that location. Was it Michael's? We don't actually know that. Does the state think it was? Does Detective Kelleher think it was? It's called guessing. We don't actually know because no body was discovered. We have no body, we have no parts of a body, nothing. No blood. They looked repeatedly. They grabbed every stain they could find. Nothing. was located. So they're guessing. Green dog toy. Well, someone who didn't testify today told someone that, yeah, we found an ear from a chew toy and it's green. Okay. What does that tell us? Absolutely nothing. Guessing. They move on to the confession. They keep calling it a confession. It is not a confession. Nowhere does Stacey Wondra confess to anything. Prosecutor says, talks about a lot of things. Wilt's trying to write himself out of the story. Except he's amazingly consistent about that. He never once says, I did this, or I did that, or I did the other. What he says repeatedly is what I saw others do, what Sarah told me. And so Detective Kelleher says, well, I don't believe that. Okay, she's entitled to that, but it's called guessing. Prosecutor has cited some cases to you. In the first one he cited, there was actually a body. There was evidence of a crime. We don't have Michael's body in this case. We have absolutely no idea what has happened to him. Frankly, we don't even know if he's deceased. Maybe you think he is. Maybe Detective Kelleher believes he is. Maybe the state believes he is, but we don't actually have any evidence that he's actually deceased. In the second case they cite, he's hanging out with the stealingest man in the county. Okay. That's not particularly applicable to this case. Stacey isn't saying, well, my wife's the kidnappingest, murderingest woman in the state. He has no idea what she's up to, has no idea what she's about to do. To commit a crime in the state of Idaho or in any state in the United States of America, there has to be a union, right? A union between intent and an act. Mens rea, that intent, and the actus rea, the act. The state has to establish probable cause that Stacey Wondra had the intent, and then he followed up with that intent, and he acted upon it. Nowhere have they established that union of mens rea and actus rea. They have guessed at it. They have guessed that he's not telling everything that he knows or that he's not being entirely honest. It's guessing. Nowhere in this case does Stacey say, I did this, or I was involved in it. He's stunned, he's shocked, he's appalled, and he doesn't know what to do. He's stuck in a nightmare that he didn't see coming, and he didn't know what to do about it. That's not murder. That's not kidnapping. It's trouble, but it's not a crime. We get to this issue of duty to report. And this is sometimes hard for civilians to kind of wrap their mind around, Judge. But a citizen has absolutely zero obligation to report a crime. Period. There are no qualifiers to that. Now, there are some mandatory reporters. Even attorneys can be mandatory reporters if we believe we've received information that someone's about to be in imminent peril or perhaps death. The ethical obligations we're under requires us to report that. There are certain mandatory reporters, doctors, for instance, counselors have to report sexual abuse, things like that. There are mandatory reporters, but regular citizens going about their business have zero duty to report a crime. And there's no criminal liability that comes appurtenant to fail to report a crime. That's the law. Now, we can talk at great length about our moral obligation or our ethical obligation. Very subjective topics that we can debate all day long, but we're in a court of law. And in a court of law, it's not a moral obligation. We don't get charged with a crime for failing morally not to tell someone about something that we see. There's no criminal liability there. Stacey Wondra gets caught up in something and he doesn't report it, and he regrets it terribly, but that is not a crime. We've talked at some length about shared criminal intent, community purpose, aiding and abetting, co-conspirators essentially, right? Stacey is not charged with aiding and abetting. He's not charged as a co-conspirator. Prosecutor's right, co-conspirators are considered principals, but he's not actually charged with that. He's charged with felony murder. He's charged with kidnapping. And in the course of that kidnapping, the child dies, so that makes it felony murder. But there was a shared criminal intent, a community of purpose. There was no such thing. And back to their initial statement of this is a unique obstacle for us to get over, it's true. Because they have to figure out how to make him a co-conspirator, because he isn't. By his own words, by everything he said, he had nothing to do with this. They walk into the house with this child, and he's like, what the fuck? He had no idea. And he was appalled, and he was shocked, and he didn't know what to do about it. That does not make him an aider and abetter. That does not give him community of purpose. He had no idea. And the prosecutor stretches these things. Well, you know, he had straps in the back of his truck, so that's the perpetuation of the kidnapping. No, it's not. The child was already kidnapped, and he had nothing to do with it. They were going to tow a car. They had to stop because the brakes weren't working. You put brake fluid in the car. Detective Kelleher says, well, that's fixing the car so they can kidnap the child. The child was already kidnapped. Standard jury instruction for aiding and abetting in the state of Idaho makes it clear, absent a duty to report, which Stacey did not have, his presence during, even his acquiescence in, or even his silent consent. That also brings us to the lack of evidence in this case, and I get it, Judge. It's a bad case. It's ugly. It's hard. This is every parent's worst nightmare. We so desperately want to find Michael Vaughan. We so desperately want to know what happened to him. His mother and father, his family and friends, they are entitled to their grief and their anger and their outrage. Nothing I say here today takes that away from them. What I'm here to say is that that doesn't make him guilty. We so desperately want to know what happened. We so desperately want to hold someone accountable. But that doesn't mean you meet the elements of probable cause to these offenses. There are no witnesses, Judge, in this case that say, yeah, I was on 9th Street or Arizona or 8th Street or wherever, and I saw Michael Vaughan and I saw this maroon GMC pickup pull up, and then I didn't see Michael Vaughan anymore. There are no witnesses like that. None. Zero. No admissions or confessions or incriminating statements from Stacey. I know that Detective Kelleher doesn't believe him. That's not enough. That's guessing. No forensics of any kind. They did all the forensics. We have 20,000 pages of discovery plus. The Idaho State Police were heavily involved. They went over everything with a fine-tooth comb. The FBI was involved. Every available resource was tied into this case. And not one piece of forensic evidence was found related to Stacey or anybody else. Cars, clean. Houses, Clean. Nothing. Piece of duct tape in the back of a truck. I would encourage you to find a truck in the state of Idaho that doesn't have a piece of duct tape in it. But that piece of duct tape could have had DNA. Michael's DNA, some skin, some blood maybe, fingerprints, whatever. Nothing. No forensics of any kind. All of the state's resources, all of the federal government's resources poured into this case, and nothing indicates Stacey had anything to do with the abduction of this child. No physical evidence. This is incredibly important to the case, and we haven't really talked about it a lot. But there's always physical evidence, right? Something that connects the perpetrator to the crime. Examples would be, an easy example would be the shirt that we knew he was wearing found in the trunk of Stacey's car, or in the backyard of his house where he's living, or in the crawl space under his house. A shoe that was known to be Michael's found in the truck. Simple, basic thing, evidence that connects a perpetrator to a crime. There is nothing of the sort. The state comes to the court today and says, we think we know what happened. We think the child was kidnapped, and we think Stacey had something to do with it. And we think he was held in the house, and he was in a car, and he was taken to Brandon's mom's house, and he was buried in the backyard. All of those things are guesses. And we can't bind over a case, first-degree murder, or any charge, frankly, on a guess. I would submit to the court that you can't take a 5-year-old boy. I'm sorry, I just find that incredibly unbelievable, that you're going to take a wriggling, kicking, screaming 5-year-old, stuff him in a duffel bag. You're going to kick his way out, he's going to thrash his way out, people are going to hear, people are going to see. I just don't find that believable. But even if you find it believable, there would be evidence. There would be evidence of his skin, of his blood, of his I'm not a CSI, the epithelials, whatever, the material from your skin. They would be on the couch. They would be on the carpet. They would be everywhere he was. He was supposedly in the back of a truck in a duffel bag. Canines don't alert on that truck. That's not believable. No evidence, no forensic evidence found in the yard, in Brandon's mother's yard, in Brandon's mother's house. It surpasses reason to think that a little boy was kidnapped and died and buried, and they didn't find anything. And I hate that as much as anybody. But that doesn't mean that a crime has been committed by Stacey Wondra. There has to be that nexus between the intent and the act, and there has to be that evidence that connects those things, and there just simply isn't. You may not like it, may not believe it, but at the end of the day, what Detective Kelleher thinks, what the state thinks, it doesn't matter. It's what they can prove. And they haven't proven anything. And it's not a trial. It doesn't have to be beyond a reasonable doubt. Is it more likely than not that Stacey Wondra kidnapped that child and he died in the perpetration of that kidnapping? No. They have not submitted evidence that even establishes probable cause. A common theme, Judge, throughout this case is Detective Kelleher hits him hard on this in the interviews. His mom, who they used to get information out of him, she hits him hard. What did you do? Why didn't you say anything? Why didn't you call? You must be accountable for your part, Mom says. You must be a man, Mom says. You made a mistake, Mom says. What that's referring to is his cowardice. This is why he's crying. This is why he's remorseful. This is why he's upset. Because something horrific happened, he didn't stop it. He was a coward. That also has no criminal liability attached to it. Being a coward is not a crime. Judge, even if you believe everything that Stacey Wondra said, and I don't think we can believe any of it, changes his story constantly, lies constantly. Much of what he says just simply isn't believable. And all of his story that is put together about what he saw and where Michael Vaughan was and what happened, none of that is corroborated by evidence. If any of it, even a bit of it, was corroborated with any evidence, game on. But it hasn't been. Nothing. Even if you believe everything he says, he still didn't commit a crime. This is not guessing court. This is not hopeful court. This is not, we have a pretty good idea court. This is a court of law. And a court of law requires evidence to prove a crime. And they haven't done that. And I know that it's hard. But they have to prove it, and they haven't. And you cannot bind it over to district court. I would concede there is probable cause, there is evidence for count 3, destruction of evidence. Related to phones, SIM card, other things. I concede that. That's the only crime they've established probable cause, Judge. Thank you.
All right, thank you. I'm going to take this under advisement for a few minutes, and come back on and announce a decision. It's my intention to do that this afternoon. We'll be in recess.
Please rise.
Go ahead and be seated. So we are back on the record again to take up the matter of State of Idaho v. Stacey Wondra in CR 38251295. Time has come to render a decision in this case, or announce a decision. That's what the court intends to do. Is the state ready?
Yes, sir.
The defense?
We are.
Before I do, this is an unusual proceeding. Preliminary hearings don't normally consume this amount of time and resources. I appreciate the decorum and the dignity shown by everyone that came and was here for much of the trial. Certainly the professionalism of the marshals in maintaining good order, and the preparation and skill of counsel in making the presentation of this case. Mr. Wondra faces in this matter for preliminary hearing today 3 counts, 3 alleged violations of law: murder in the first degree, kidnapping in the second degree, and destruction or alteration or concealment of evidence about to be discovered in the investigation of the commission of a felony crime. The question before us is not the question that's asked at the end of a trial. And at a preliminary hearing, there are specific questions being asked, and the evidence must meet or must answer those questions in order for a case to proceed to trial at all. The first of those questions under Criminal Rule 5.1 is whether or not a public offense has been committed. And then thereafter, is there probable or sufficient cause to believe that the defendant committed those offenses? In order to make that finding, a judge must find that the probable cause has been presented, and it must be based on substantial evidence on every material element of the offense charged, or in this case, the offenses charged. The evidence presented in this case supports the conclusion that Michael Vaughan was abducted, he was secreted away, and he was killed in the course of being secreted away. The evidence goes on to show that subsequent to and during those events, evidence of the crimes was destroyed, altered, or concealed. In making findings of probable cause in this case, or in any case, the court relies primarily on the criminal code, the statutes by which a person is alleged to have committed a crime. The court also relies heavily on the jury instructions that the Supreme Court has promulgated for making decisions about any particular charge. A particular utility in this case is Idaho Criminal Jury Instruction 311 and 312. 311 says that the law makes no distinction between a person who directly participates in the acts constituting a crime and a person who either before or during its commission intentionally aids, assists, facilitates, promotes, encourages, counsels, solicits, invites, helps, or hires another to commit a crime with the intent to promote or assist in its commission. Both can be found guilty of the crime. Mere presence at, acquiescence in, or silent consent to the planning or commission of a crime is not, in the absence of a duty to act, sufficient to make one a principal. An accomplice is what it says, but we're talking about principal liability for criminal acts. Idaho Criminal Jury Instruction 312 says that all persons who participate in a crime, either before or during its commission, by intentionally aiding, abetting, advising, hiring, counseling, procuring another to commit the crime with intent to promote or assist in its commission, are guilty of the crime. All such participants are considered principals in the commission of the crime. The participation of each defendant in the crime must be proved beyond a reasonable doubt. And that last piece is just for the jury. And here, that's not the standard, right? The standard is whether or not probable cause has been demonstrated. Here, Mr. Vaughan is charged, or Mr. Wondra, I apologize. Mr. Wondra is charged as a principal, and the court considers the evidence in this case through that lens. When I make any decision, I base that decision on the evidence that's presented. I certainly never make a decision based on hopes or guesses, based on the underlying subject matter of a case, no matter how tragic or innocuous. That is not part of a decision that a court uses, and certainly that I use when reaching some conclusion or decision. This court finds that substantial evidence has been presented as follows: that on or about July 27 of 2021, in Payette County, state of Idaho, Stacey Wondra seized, confined, unveiled, or kidnapped Michael Vaughan with the intent to cause him, without authority of law, to be secretly confined or imprisoned within the state or detained against his will. Or that Stacey Wondra took, enticed away, or detained Michael Vaughan, a child under the age of 16, with the intent to keep or conceal the child from his custodial parents, in violation of Idaho Code 18-4501 and 4503. That in the perpetration or attempted perpetration of the felony crime of kidnapping on or about July 27 of 2021 in the state of Idaho, the defendant engaged in conduct that caused the death of Michael Vaughan, unlawfully killing him without justification and with malice by taking intentional acts, the natural consequence of which were dangerous to human life and deliberately performed with knowledge of the danger and with conscious disregard for human life, constituting murder, and that such murder was committed in the perpetration or attempted perpetration of a kidnapping in violation of Idaho Code 18-4001, 4002, and 4003. That on or between July 27 of 2021 and May 21st of 2025, in Payette County, state of Idaho, Stacey Wondra willfully destroyed, altered, or concealed evidence concerning the kidnapping and murder of Michael Vaughan, including but not limited to biological material, physical evidence, and digital information, knowing that these things were about to be produced, used, or discovered as evidence in a felony investigation, and with the intent to prevent that evidence from being produced, used, or discovered. These findings are made more than anything else on Mr. Wondra's statements to investigators. He described the abduction of Michael Vaughan under circumstances corroborated by other witnesses. He described the binding of Michael Vaughan together with him being secreted away to Cuna and his role in assisting that effort. That too is corroborated by physical circumstances confirmed by the investigators in this matter. He described the manner of death and the subsequent disposal of the body, with some of those details also corroborated by the results of the investigation. Finally, he described his role in destroying and disposing and concealing of many pieces of evidence that were about to be discovered during the investigation that was being conducted. The question before this court is not whether or not Mr. Wondra is guilty of these three charged offenses beyond a reasonable doubt. That is not the purpose of a preliminary hearing. That ultimately will be a question for a jury after a full trial. But I do find that the evidence demonstrates that the public offenses charged have been committed and that there is probable or sufficient cause that the defendant committed them. And so I will bind Mr. Wondra over to district court to answer for the charges of kidnapping in the second degree, murder in the first degree, and destruction or alteration or concealment of evidence. Madam Clerk, I think we have a date for that. All right. So what's proposed is that Judge McCarthy would preside over this case, and we would set an arraignment in front of him. I have half a dozen dates here, the first of which is April 1, 2026 at 3:30.
Judge, the defense cannot do that.
What about April 8th at 2 p.m.?
Sorry, that would be negative.
What about the, and I have some dates in between, I'm just trying to skip ahead, I don't know how tight your calendar is. What about the 14th of April at 10 a.m.?
I can make that work.
Well, would the 15th of April at 10 a.m. be better?
It sure would. Thank you.
Does that work for the state?
It works for the state.
All right. Anything further that the state believes should be presented today?
No, Your Honor, thank you.
April 15th. Yeah. Anything further that the defense wishes to present today?
No, Your Honor.
Thank you.
All right. Thank you. We'll be in recess.
Ms. Price?